Assalamu alaikum. Welcome to Just Law on Ikra TV. My name is Bilal Hussain Khan and I will be with you for the next hour. And as our regular viewers are aware, that on Just Law, what we aim to do is deal with a new topic every week and also take any questions that the viewers may have on any aspect of English law, be it criminal law, immigration, be it family, etc. etc. Now, there will be a number at the bottom of your screen with a telephone number, and it is a live show, and our viewers are urged to give us a call and ask any question that you have. And because of the nature of the show, sometimes we may need to look at documents or ask further probing questions regarding your particular circumstances, and if that is required in order to advise you appropriately, I will ask that you contact the control room and ask them to provide us your details, and what we'll do, we'll aim to get back to you within the next couple of days, and I will deal with your case on a one-to-one basis. However, viewers are urged to contact us on the telephone number and ask any question, and then I will attempt to answer that question in full. For any reason, if I can't answer that question, if it's regarding another area of law that I'm unfamiliar with, I will take the details down and I will answer it on the following week. Now, for those of you who do tune in and look at our show on a regular basis, you will note that we have been talking about criminal law, in particular rights and entitlements whilst at police custody, and also the police caution, etc., which is the fundamental right for a person. Now, for today's session, what we're going to discuss is assault and the defences available at law and the different assaults. Now, some of you may be aware that there are different classifications of an assault. Now, assaults can be a common assault, can be a battery, which is a section 39 assault, and then there may be actual bodily harm, which is a section 47 assault, and thereafter it's a causing wounding to a person, and that may be without intent, and then there's a wounding with intent, and those two offences are contrary to section 20 for wounding without intent and section 18 for wounding with intent. Now, generally speaking, insofar as any assault is concerned, the definition of assault is causing a person unlawful violence, and for a section 39 is also causing them to apprehend unlawful violence. So to be guilty of an offence contrary to section 39 assault, it may be a case that you've clenched your fist and you've gone towards a person without even having any physical contact with that person. If that person feels or fears that he will be subjected to unlawful violence, then you can be guilty of an offence which is a common assault. Now, it's important to know that no physical contact is required for you to be guilty of an assault. Now, what are the different elements? Now, there's obviously an overlap between all offences. Now, it may be a common assault, and insofar as a common assault is, it may be a case that you've punched somebody. It may be a case that you've kicked a ball and the ball has hit a person, and that person complains for an assault. And it may be a case that you've dropped a ladder and the ladder has fallen onto a person. Now, in order to be guilty of an assault, it has to be either an intentional act or it has to be a reckless act. Now, there's two differences. Obviously, for an intentional act is for the prosecution and the police to prove beyond reasonable doubt that you have committed the offence. So the offence is that you've intentionally done the crime. So for argument's sake, you've intentionally assaulted the person. Now, it becomes a bit more difficult for them when they say it was reckless. So for argument's sake, insofar as reckless assault takes place, so if there's a crowd of people and you have an item in your hand, you've thrown the item to a person with the aim for that person to catch the item, but rather than the person catching the item hits another person who was part of that crowd, then you can be guilty for an assault on the basis of being reckless. So when you threw the item, there was a large crowd and there was a possibility, or there should have been a possibility in your mind, that when you threw this item, that it would have hit one of the person. Therefore, although you've not intentionally done it, you are reckless as to whether or not the item would have hit another person. So depending on the level of the injury, then the police will determine whether or not this is a common assault, this is an actual assault, or whether it's wounding, and with wounding is with intent or without intent as well. So if we use the same analogy and talk about throwing something, so if you've thrown an item at a group of people and your intention was for someone to catch that item, the person misses and it ends up hitting somebody and causing a wound. Let's say the person's caused a laceration to his head, and then you will be arrested for an offence of Section 18, wounding with intent, or possibly wounding without intent. However, it'll be quite difficult for you to prove the fact that you were not reckless as to whether or not the person would have been hit. Now at that stage is for you to put forward your defence, and then the only defence is whether or not it was an accident. And under those circumstances that I've just talked about, whether it was an accident to hit that person or not, it's going to be quite difficult for you to show, because if you're not the best thrower in the world and then you've ended up hitting a person on the head, it's for you to show that, look, I would have passed it over to the other person, and I've always passed it over to that person. We'll just take a call and then we'll move back to this. Assalamu alaikum.
वालेकुम सलाम, कैसे हो? तबीयत ठीक है
जी अल्हम्दुलिल्लाह ठीक ठाक, आप कैसे हैं? ठीक है
जी, अल्हम्दुलिल्लाह अल्हम्दुलिल्लाह। अच्छा, मेरा एक सवाल पूछना था आपको।
जी।
मेरा फ्रेंड ही पाकिस्तान से आया था।
अच्छा।
उसकी अभी 3 साल हुआ है शादी का
जी।
और उसकी बीवी के साथ उसका कोई फाइट हुई थी ना
जी।
तो उसने थप्पड़ मार दी थी।
अच्छा।
तो उसको जेल के अंदर में सेंटेंस हुआ है, अभी उसको जेल के अंदर में है वो।
अच्छा।
और उसकी ब्रिटिश पासपोर्ट भी अभी नहीं हुई है।
अच्छा।
तो ये इमिग्रेशन के ऊपर इफेक्ट करेगा?
जी, तो अभी वो सेंटेंस उसकी नहीं हुई?
नहीं, सेंटेंस
नहीं, सेंटेंस ठीक है। सेंटेंस नहीं हुई या हुई है?
हुई है।
अच्छा, तो कितनी सेंटेंस?
नहीं, वो तो ऐसे ही उसको ले गए थे, बाद
वो
में
रिमांड
अभी कोर्ट के ऊपर जाए।
हाँ ठीक है, तो अभी वो रिमांड हुआ। तो मसला यह है ना कि जब कोई भी आदमी अरेस्ट हो ना, तो फिर पिछले हफ्ते मैंने पता नहीं आपने प्रोग्राम देखा या नहीं, तो मैंने ज़मानत के लिए एक्सप्लेनेशन दिया था कि ज़मानत के लिए क्या करना चाहिए अगर आपको चाहिए। तो अगर पुलिस या कोर्ट ये सोचें कि अगर आपके दोस्त को ज़मानत पर अगर छोड़ दिया तो फिर ये खतरा है कि वो या दोबारा ऐसे करेंगे या वो भाग जाएंगे, तो फिर वो रिमांड के लिए जो है ना, तो वो जेल में चले जाएंगे अवेटिंग द आउटकम ऑफ द केस। तो ये जो आपने कहा ना कि उसने थप्पड़ मारा अपनी बीवी को, तो ये जो है ना ऑर्डिनरली अगर इंजरी ना हो तो ये सेक्शन 39 या सेक्शन 47 असॉल्ट होगा ना, ठीक है। तो इसके लिए सेंटेंस वो क्या करेंगे कि प्री सेंटेंस रिपोर्ट लेंगे, प्रोबेशन के साथ आपकी दोस्त की अपॉइंटमेंट होगी, तो फिर वो डिसाइड करेंगे कि इस एलिगेशन के लिए वो क्या सज़ा होनी चाहिए। या ऑप्शंस ये हो सकते हैं कि या क्योंकि ये डोमेस्टिक असॉल्ट है तो फाइनेंशियल पेनल्टी यूजुअली नहीं होती, तो क्या करते हैं कि वो डोमेस्टिक वायलेंस का कोर्स हो सकता है कि दें, डिपेंडिंग ऑन आपका दोस्त का अगर प्रीवियस कभी कोई प्रॉब्लम हुई है या नहीं। अगर प्रीवियस प्रॉब्लम नहीं हुई तो 9 out of 10 टाइम्स उसको जो है ना ये डोमेस्टिक वायलेंस कोर्स मिलेगा, ठीक है। तो वो कहेंगे कि आप ये कोर्स करें, तो ये विक्टिम अवेयरनेस कोर्स करें या कोई अनपेड वर्क करें, ठीक है। तो अगर 12 मंथ्स जेल से अंदर हो ना, तो अप टू 12 मंथ्स जेल वो हो सकती है, तो वो उनकी इमिग्रेशन की डिपोर्टेशन के लिए प्रॉब्लम नहीं होगा। लेकिन अगर 12 मंथ से ज़्यादा सज़ा हुई ना, तो फिर जो है ना डिपोर्टेशन हो सकता है। लेकिन इस वक्त जो है ना अगर उन
ब्रिटिश पासपोर्ट नहीं है ना उसके पास,
हाँ
पाकिस्तान की पासपोर्ट ही है
ये तो उनका या होगा वीज़ा, टेम्परी वीज़ा होगा ना, स्पाउसल वीज़ा, या इंडेफिनिट लीव टू रिमेन होगा। तो इन दोनों पर जो है ना ये ब्रिटिश पासपोर्ट का थोड़ा प्रॉब्लम हो सकता है कि अगर कन्विक्शन हो, लेकिन वो डिपोर्टेशन का मसला नहीं होगा इंशाल्लाह। तो
कुछ नहीं, मैं इंशाल्लाह मैं आपका नंबर ले लेता हूँ
जी
और आपका इंशाल्लाह मैं रब्ता करूँगा, आपके साथ
जी
कांटेक्ट करूँगा।
इंशाल्लाह ज़रूर, ठीक है। अस्सलाम वालेकुम। For our English speaking viewers, the question asked was the caller's friend is currently on remand for an allegation of domestic assault against his wife. The allegation is that he's assaulted his wife by slapping her, and he was asking what the position is in respect of that, and also whether or not that conviction will affect his immigration status or not. Now, insofar as the remand aspect is concerned, I spent the best part of the last program talking about what package you need in order to grant a person bail, what the prosecution or court, what their concerns need to be in order to remand a person in custody, and then what kind of bail package you need to have. Now, if it's a domestic related incident that's been complained of, and if there's no alternative address available, then ordinarily the court, in order to safeguard the victim, will remand the suspect into custody until the conclusion of the case. Now, if there is an alternative address available, which is at a distance away from the complainant, so for argument's sake, a different city, a couple of miles away, etc., and there's a condition not to go within 100 meters or even into the same city, and then ordinarily the court will entertain a bail application. Now, the second issue is as to whether or not that would affect the immigration status. Now, with any crime, if a sentence is imposed exceeding 12 months in custody, so that's 12 months. So if you receive a custodial sentence of more than 12 months, then what you'll receive whilst that prison is a deportation notice. Now, the deportation notice is issued to everyone who's not a British citizen. So if you've attended United Kingdom on a spousal visa, and if you've got indefinite leave to remain, or if you're on a temporary visa, if you receive a custodial sentence of more than 12 months, then you'll be served with deportation notice. Then what you will need to do is you will need to make an appeal and then make representations to the Home Office as to whether or not that deportation order should proceed, or whether or not you should have the right to remain within the United Kingdom. And every case is dealt with on its own merits, and it depends on the personal circumstances of the person involved who's been served with the deportation notice. Now, we've had cases previously where there's people who have been convicted of possession with intent to supply controlled drugs allegations, served with deportation notices, and we've managed to make representations in order to keep them resident in the United Kingdom. And similarly, we've had cases where they've been charged with offences and got custodial sentences of more than 2 years for either sexual or physical assault cases. And in those circumstances as well, depending on the person's individual circumstances, we've managed to have the deportation decision reversed by the courts on, but all of these are dealt with on a case-by-case basis. Now, that's only if you don't hold a British passport. Now, if you hold a British passport, then there's no problems. You're not going to get deported if you receive a custodial sentence of more than 12 months. Now, in the circumstances where you're on a temporary visa and you've been convicted of a crime, be it a road traffic offence, be it an assault or anything, then it will affect your nationality application. So when it comes to time where you want to apply for nationality and you've got a conviction of an assault on your record, then that will automatically bar you from applying for nationality, because nationality is a privilege, it's not a God-given right. So what the Home Office will say is, look, because of your conduct, because of your previous convictions, we're not going to assign nationality to you, even though you meet all the requirements, etc. You're going to have to wait, and all of your convictions will have to be spent, and then under the Rehabilitation of Offenders Act, etc., representations can be made. And then if you've been clean for a period of about 10 years or so, and then an application can be made for nationality in order for you to receive a British passport. Now, all the viewers who do have indefinite leave to remain and are eligible for nationality, our advice would always be that you should apply for your nationality status as a matter of urgency. Whenever you're eligible, you should make that application. You need to meet the requirements, do all the courses, etc., and make the application as soon as possible. But if it's a case that you've been served a deportation notice, it's not the end of the day. You should always consult with a solicitor who specialises in these kind of matters, and then your individual cases will be dealt with on a case-by-case basis, and then a decision can be made whether or not it's in the interest of justice or human rights to deport you, or whether or not that deportation notice can be challenged and you can remain in the United Kingdom with your family. Now, we were talking about assaults, and it's important to know that insofar as the assaults are concerned, there are separate guidelines for domestic assaults, which is an aggravated feature. So, like I've already discussed, there's different classifications of an assault. So you still have a Section 39 assault, which is a common assault. You have a battery, you have Section 47 assault, Section 20 and a Section 18. However, if it's done in a domestic contents, then there's separate sentencing guidelines, and what that'll mean is that you'll receive a different sentence. It'll be aggravated by virtue of the fact that the offence is committed to a family member, be it can be a spouse, it could be your husband or wife who's been assaulted by the other, it could be parents assaulting their child, it could be children assaulting their parents, etc., vice versa. If it's done in a domestic incident, and then the sentencing guidelines differ, and usually they're a bit more stricter when it comes to domestic because of the nature you can find within a house. And then if you are subjected to a domestic incident, there's nowhere for you to run, hide, there's no witnesses, etc. So the police and the courts normally take a more stern and more strict approach when it comes to domestic related incidences. Now, whilst we're talking about domestic related incidences, you will find that quite a lot of people are now arrested for another offence, which is controlling and coercive behaviour. Now, controlling coercive behaviour normally is with partners, or it could be with your in-laws, etc. And it's under those circumstances where someone says that I've been restricted in what I do, my partner, etc., doesn't want me to wear particular clothes, doesn't want me to associate with my friends, my family, doesn't give me a mobile phone, controls what I do, controls what I wear, etc. Under those circumstances, the prosecution will look at a more serious offence, which is engaging in controlling and coercive behaviour. Now, that's an either way offence, which means that it can either be dealt with in the magistrates' court or the Crown Court. And over the last 4 or 5 years, we've seen more and more people being arrested for those offences. And in order for you to be guilty of that offence, then the prosecution have to prove the case against you beyond reasonable doubt, and they have to prove that you've been restricting that person's movement, you've not been letting them out, and that's normally backed up with evidence which is provided from friends, from family, etc. And if you are ever questioned for an offence under this Act, is always recommended that you speak to a solicitor, and the solicitor's advice is normally, depending on your personal income, free of charge. If you're earning less than £30,000, generally for Crown Court cases, £12,500 for magistrates cases, then you'll be eligible for legal aid. And at the police station, everyone is eligible for legal aid. It's not means tested, so no matter if you're a millionaire, billionaire, or whether you're on benefits, you're all entitled to a solicitor free of charge at the police station. And it's always important to get advice of a solicitor at that stage. Now, the advantage of having a solicitor with you is because you get pre-disclosure, pre-interview disclosure. The evidence is given to the solicitor. The solicitor then can speak to you, seek your instructions, advise you of the law, advise you of the defences of law, and then at that stage you can either answer questions or exercise your right to silence. Like we've previously discussed in previous shows, is for the prosecution to prove the case against any person beyond reasonable doubt. It's not for a suspect to prove their innocence at any stage. It's the other way around. It's for the police or the prosecution to prove that the person's committed an offence, be it an assault, be it controlling or coercive behaviour, and the suspect can remain totally quiet and not say nothing at the police station, can go to a court, remain totally silent, not say nothing, and if the prosecution cannot prove beyond reasonable doubt, then the person is not guilty of the offence and does not even have to say anything. Now, the second part of this show, we'll talk a bit more about the other classifications of an assault and what the defences available at law are. We're just going to go for a short break at this stage, and I will see you in a few minutes.